Can you guys hear the sirens? It's the sirens of downtown LA welcoming you to the live. Welcome, everybody. Welcome, everybody. Let's see if we can wait a few minutes and get some people in here. I did have this scheduled for, got my East Coast, Pacific Coast times a little mixed up. So I have this technically scheduled on YouTube for a little bit later, 3 hours later. But I just switched it to 6 p.m. Pacific. So let's get in here and see what everybody is doing. Again, we're doing a update on the Young Thug trial, and we're going to talk to Doug Weinstein, who's Deamonte Kendrick's attorney, Yak Gotti's attorney, and he's actually one of the attorneys who filed the petition that's currently with the Georgia Supreme Court about Judge Glanville. And I know everyone is wondering what's going on with that. We haven't seen any movement, at least not in since I checked it. It's one of those things where I can't get notifications for this. I just have to check it every 10 minutes to see if there's been a filing. But no, we'll talk to him about what's going on with that. And I don't want to waste any time going over the document when we can do that. He's got a limited amount of time. So we'll put him on screen here. Hi, everybody. Hi, April. Hi, The Secret Ninja. Thanks for tuning in. Let's get going here. Let's see. Yeah, Doug, thank you so much for joining us. We've got you on screen. Again, everybody, this is Doug Weinstein. He is Deamonte Kendrick's attorney. You might see him there in court, and he brought the recusal motion against Judge Glanville, and then after that was rejected, his team, he can talk about that because he did say on Twitter that there was an attorney who looks like is from an outside firm, but is working with him on the case, did a lot of writing on that. But they've got a petition pending with the Georgia Supreme Court. Doug, can you talk about how that came together? And well, first of all, when do you think we might get a ruling on that? And you did say something about it possibly being kicked to a lower court. Can you speak to why you think that might happen? Or
Sure. So, yeah, we filed our motion for recusal 2 weeks ago, and then he denied it from the bench. Judge Glanville denied it from the bench. And again, as I told him in court for folks that were watching, I don't think he really followed the procedures that he was supposed to go through under the rules. So on Friday, that following Friday, so about a week and a half ago, he entered an order formally denying my motion for recusal. And then I guess last week, while I was out with COVID, as everybody knows since Judge Glanville seemed to announce that to the whole world, I drafted that petition to the Supreme Court along with Katie Hingerty. Katie Hingerty has 25 years of experience in criminal law, and she's also one of Deamonte Kendrick's attorneys.
Oh, right. I've seen her in court. So she is technically a solo practitioner in Atlanta, but she works with. Has she worked with you guys on other cases, or is it just?
She has her own law firm, but she also does work with the Yak law firm, and that's who I'm with. Okay. So she does both. She and I worked. I kind of went through and did a first draft, and then she and I polished it up. She's a great writer, which is the reason it reads as well as it does. To the extent it does read well, those are her efforts, because she's the journalism major and I'm the electrical engineer. So,
is she a former reporter? Did you mention her?
I don't think so. But I know her undergrad degree is in journalism. Okay. So she polished that up with me, and then we filed it Thursday. So it'll be a week tomorrow. Under the Supreme Court rules, our Georgia Supreme Court has original jurisdiction on certain matters. Including petitions for writ of mandamus. But under the Supreme Court rules, the Georgia Supreme Court rules, when you look them up, they arguably will only hear a petition for a writ of mandamus of a judge, for recusal of a judge, if you've first gone to that county and filed a petition there, and that has proven to be fruitless.
And
So what we tried to do is argue, and we tried to argue in our petition that several petitions for writs of mandamus had been filed in Fulton, specifically relating to Judge Glanville, and those petitions have gone nowhere. So what we tried to argue if you read our petition, what we tried to argue to the Georgia Supreme Court was, look, it would be pointless to go to Fulton because our experience in this trial is petitions for writs of mandamus. Just, I guess, as I put it, they go to Judge Glanville's chambers to die.
Yeah. So this would be a step on top of the recusal motion that Glanville rejected. You're saying there's some argument that they could turn around and say, no, first you have to go to the Fulton County Superior Court. And who would rule on it? Would it be Glanville as the chief judge, or?
Well, if for some reason the Georgia Supreme Court declines to hear our petition, then we're prepared to file in Fulton a similar petition. And if we were to file that in Fulton, I believe that it would be randomly assigned to another judge. That petition, I've heard multiple things on that, but I think in all likelihood it may not go to Judge Glanville. It may go to somebody else. And just to be clear on that petition, because there's some confusion I've seen on the internet about it. Yeah. All we're asking for in our writ of mandamus is we're asking that the Supreme Court order Judge Glanville to follow the rules. And based on Judge Glanville's findings that our motion for recusal was filed in a timely basis, the affidavit dotted the I's and crossed the T's, and pretty much made a prima facie case that he should be recused. Under that standard, following the rules, Judge Glanville should have kicked out our motion to another judge to hear the recusal. So all we're asking the Georgia Supreme Court is order Judge Glanville to follow the rules and have another judge hear our recusal motion.
Right. They wouldn't actually make the step of recusing him, nor would they be ordering a court to recuse him. They're just saying, send this to another judge to decide whether he should be recused.
I mean, they're the Supreme Court. I guess they could do a number of things. I can only tell you what we asked for. So what we asked for were three very specific things, which were order him to follow the rules on a recusal motion and kick it to another judge for deciding on recusal, order a release of the unredacted transcript of the secret ex parte hearing that took place or meeting, and also I'm sorry, I'm tired, it's late. The third thing we asked for was, I'm blanking now. I'm sorry, I'm just so tired. But, and then we asked for any other relief that the court may deem appropriate. So if the Supreme Court wants to, and thinks they have the power to do that, just on the papers, if they want to recuse him, more power to them. But I think it's time for another judge to hear this case.
Yeah, and are you anticipating? I mean, there's no telling what they're going to deem a timeline for this emergency petition. Is that correct? I mean, are you?
No, all I can tell you is under the Supreme Court rules, a reply brief from Judge Glanville is due basically as soon as possible. There's not a specific time frame listed, and it is possible the Supreme Court can act before receiving the reply, although I doubt that will happen. It is the State Attorney General's office that represents judges in these petitions for mandamus. So someone from that office will be representing the judge.
Okay. So that's obviously something to keep an eye out for, is the response on that. Because what I thought was interesting was you really turned around and were able to quote the judge's own ruling in that 7-page order he issued, where he rejected the recusal motion formally. This is after he made the oral ruling. He seemed to almost kind of write himself into a corner when I'm reading this, because he's going to make it hard for the court not to send it to another judge when he has that line about the pleadings are sufficient, or I can pull up the exact quote in the pleading, but he said this is sufficient. However, they lack evidence. And as you point out in your motion or in your petition, they lack evidence because the transcript hasn't been released. But it seems like that statement in itself, that these allegations are sufficient. I mean, did he kind of screw himself over with that? I mean, that kind of seems to acknowledge the basic law that you're saying is being violated here about not sending it to another judge.
Yeah, I think that what happened is that he took the analysis a step further than is appropriate for him to take. So yeah, he made the finding that I think he made the finding. I'm pretty sure he did when you read his order, that the affidavit on its face would merit recusal. But as you say, then and that should have been enough. That should have been the end of the analysis. Once he makes that finding, according to the rules, I believe he should have kicked it over to another judge to make a decision on recusal. Instead, he went an additional step, and this is outlined in our petition. As you say, he went that additional step to say, well, you say this, but you don't have evidence backing it up, which I found frustrating.
Yeah.
Because why don't we have evidence? It's because he's refused to release the transcript.
Right.
And the affidavit is evidence. But anyway, the whole issue of evidence, that's not for Chief Judge Glanville to consider. That's if another judge wants to look at this, have a hearing, decide on the papers. If that unbiased judge looks at this and they say, oh, it doesn't merit recusal, well, okay, perhaps that's the case. But that's not a decision that Judge Glanville should be making.
And he's got that chambers meeting scheduled next week to go over the transcript. Do you consider that to be sufficient in releasing the transcript, or is it does that just remain to be seen until the hearing happens and you see what's redacted and what's not there?
You know, that meeting is just that he's called the in-camera hearing.
Yeah.
I don't know. I don't I don't know what to say about that, because I'm unclear if we are in the in-camera proceeding, which of course isn't going to be open to the public, despite the objection that Brian Steele lodged today. That in-camera proceeding, I'm not clear if we are going to get to see the entire transcript, and then Judge Glanville will make rulings that portions of that proceeding are privileged. So we, the lawyers, will see it, but we'll see all of it, but maybe only portions will be made public. I'm unclear. And I think he made a comment today in court, which was that, basically details of how that in-camera hearing will take place will be divulged, I guess, at the start of that hearing on Monday. Okay. But it's still a mystery to me. And I think I said this, I'm not saying anything here that I haven't said in the petition. It's a mystery to me what in that ex parte hearing could be privileged when you had the judge there, the court reporter there, prosecutors there, investigators, deputies, and then you had the witness and the witness's attorney there. I mean, I don't know what privilege could possibly apply to any discussion that took place. And I guess, but Judge Glanville's pretty sure there's something there privileged, and it'll be fascinating to see what he thinks that is on Monday.
Right, because it seems like the only person who would hold any privilege in that meeting is Woody. I mean, because you're saying the information being passed around when you've got all those people, you've got the jailers there with them. It's not privileged, but I mean, whoever's representing Woody as a lawyer would have an ethical duty to him if that's his wishes to not disclose that, right? I mean, that's just a private issue between Woody and his attorney, basically.
Right. But again, how could any conversation between Mr. Copeland and his attorney, how can that be privileged when there were third parties present? And I'm not talking about the jailers. Occasionally you can have circumstances where jailers need to be present. But when you have the prosecutors there, when you have the judge there, how can any of that be privileged? And I'm trying to come up with scenarios where I can find privilege. But then if it's in the transcript, the court reporter was there. So I don't know what privilege Judge Glanville thinks is there. Because
Glanville pretty well implied that this was Woody's stand-in attorney. Kayla Bumpus, at least if you kind of read into what he's saying. But she's gone on camera and then, implied that it wasn't her. Is there, is there any talk about that? Is it just a given that Glanville knows who it is, or could something be coming here?
I don't know. When he was in the middle of his discussion with Brian Steele, that Monday that he held Brian in criminal contempt, he uttered at one point from the bench something to the effect of, he pretty much knows who or suspects who it is.
Yeah.
He didn't utter any names from the bench, but it seems that he has an idea in his head of who he thinks it is. But again, I think, as I've said to you before, that I don't really care about the leaker. I know who the leaker is because I was present in the meeting with Brian Steele where we got the information. But I have no plans to disclose who gave us that information. Besides, I don't believe, we'll see. I don't believe anything that happened in that meeting was under a requirement to keep it secret. And I've read the motion filed by Kayla Bumpus's attorneys, and I believe they assert that.
Yeah. And it seems like, just given the process and given his confusion up to the very end, the judge's confusion about civil contempt versus criminal contempt. We saw Ashley Merchant representing Brian Steele kind of try to educate the judge on the differences there. It seems like, in my opinion, it's pretty much a given that contempt finding is going to be overturned, but it could be a couple of months from now. And does that give Brian Steele any kind of added standing to bring a recusal motion? It seems like everyone's expecting a recusal motion from him too. I don't know if you can.
He's already filed a recusal motion. Brian
on top.
A petition.
A petition on top of the recusal motion. Do you think that would give him any more legal standing than you do, or?
I don't know. I don't know about that because I actually haven't really looked into the whole issue with the finding of contempt by the judge against Brian. But if and I'm sure you read Brian's motion for recusal, and Brian has been the subject of treatment in court that is. The judge has always been nothing but courteous to me in court and never said anything in front of a jury in any way to damage me. But he has certainly said some things that I believe were inappropriate to say in front of a jury to Brian. And I think that in watching this over the last 18 months, as much as I have tried to believe that the judge was unbiased and his rulings were based on his best job of ruling on any given issue, I think after the last couple of weeks, I firmly believe that he's biased. And Brian's, the reason I go there is because Brian's motion gets into a lot more. His motion for recusal gets into a lot more than just that one ex parte meeting. Mine is more focused and narrower, where all I'm complaining about is that the judge did not follow the rules. So we'll see. Brian has a lot to complain about because the judge has tried to jail him for 20 days, I think for no good reason.
And it seems like he's just been kind of chomping at the bit here. I was actually reminded by somebody on Twitter about the moment when he yelled at you guys that his colleagues in federal court would probably jail most of you. And then it's like, oh, well, here we are today. And I was trying to think, I was like, I don't think I think it would just be a lot different seen in federal court. But as somebody who covers a lot of federal court in LA, all this jailing and contempt of court talk, it's kind of shocking to me. I've never seen it, but I was struck when I read the Christina Peterson, the Judge Peterson, who just got removed from the bench, the probate judge. And I'm wondering, is there more of a culture of contempt of court in like Southern superior courts, or it just seems like he was so gleeful to have the jail threat a couple months ago, and then it seems like it was just a week or a week and a half before the actual jailing, where he threatened it over making side comments in front of the jury. He said,
Yeah.
I'd
You know, I certainly have a lot more experience in federal court than I do in the state courts. And I will say that as far as a generalized observation, I mean, I have been in hundreds of cases in federal court all over the country, California, Texas, Virginia, I mean, Delaware, everywhere. And I don't remember contempt being thrown around, or threats of contempt being thrown around the way that they're thrown around. And I'm not going to just limit it to Glanville's court, but in general, in the state and superior courts of Georgia, I don't really see that. And also, I would say that it's just very different practice. Federal courts are I mean, they're more, what's the word I'm looking for? Everything is more organized. Everything is more set. The rules are more strictly followed. They're more predictable, far more predictable. That should have been the first thing I said. It's just, and it's a bit of a different atmosphere. And there's also no doubt that a federal judge really is a king. I mean, they have huge amounts of power that an elected superior court judge does not really have.
So it's funny that we have this superior court judges are the ones who are yielding contempt of court charges.
It's interesting, right?
It was interesting in Judge Peterson's removal from the bench order that it seemed like the big issue was how she handled what she thought was somebody giving her an altered document. She ended up jailing this person for criminal contempt of court for 20 days. And I'm like, okay, where have we read this before? And it was completely out of line. And it was the disciplinary thing was all about that. But I'm like, to me, I'm reading this. I'm like, this is learned behavior from someone. Like this to me, it showed that perhaps contempt of court is like a little more common in Fulton County Superior Court than I realized. But
Judge Peterson, who had only been barred since 2013. So she had very limited experience before, and she's the probate judge in Douglas County, of course, that the Supreme Court ruled yesterday is going to be thrown off the bench. But she doesn't have a lot of experience before taking the bench. So I don't know where she would have had a lot of opportunity to learn this particular behavior. And I think she's a one-off exception. I don't think that she's in any way typical of the judges that we have in Georgia. She's an inexperienced judge. Her behavior reading that opinion was just insane.
Oh, yeah. I mean, while there are a couple things like the contempt of court, it's just completely different. I mean, the idea that a judge like Judge Glanville, who is just head and shoulders above, a probate judge in Douglas County or Fulton County, the idea that he would ever be subjected to some kind of disciplinary tribunal or something. And that's not at all what you guys are suggesting here. I mean, to be clear, the process that removed her from the bench completely is really completely different from the petition process and the recusal process going on here, right? This is more just litigation.
I have not gone to the Judicial Qualifications Commission, the JQC, which is the body in Georgia responsible for disciplining judges. We have not asked the JQC to discipline Judge Glanville. In the case of his treatment of us and of Mr. Kendrick, we're just asking that he be recused in this case.
Because I want to
leave it to I leave it to other counsels to decide if Judge Glanville's treatment of them and their client merits going to the JQC. But we've decided not to do that.
Yeah, because I mean, reading into the case law, because I've seen the case that Steele cites that says, I mean, a judge can be recused for doing this, like dressing down an attorney in front of the jury like this. And I mean, frankly, as somebody in California, like looking at you guys as a red state, I'm like, when did Georgia become a bunch of sissies? I'm like, is this really like, how often is this applied? Because I mean, maybe it's just federal court, but I mean, the judge in this NFL ticket has been not to the extreme of in that case law, but he's been criticizing the plaintiff's attorneys a lot in front of the jury. And it just seems kind of like, to me, it's always felt like there's just nothing they could do about it. And I hadn't seen actual case law that says, there you go, you can get kicked off for that. I'd like to see how often.
I think the case law in Georgia does a good job of trying to protect the fairness of trials, and it really emphasizes not even having the appearance of impropriety. And there's a really, I don't know if you saw it, there's a really good couple of lines in the Peterson decision from the Supreme Court that would seem to directly apply to our case. And I'm certainly going to use portions of that opinion if we get to a situation where I need to do any kind of an argument, or if I have to file in Fulton, um, because I think it really goes to what Judge Glanville has done here in not following the rules.
And
Because, at this point, honestly, at this point, after what happened with that meeting, now you don't want a situation with the trial where the public is questioning whether the trial was fair or not.
yeah,
And now you wonder, is the public going to think, well, what were there other secret meetings that we just weren't made aware of? What's going on here? And so I think, as I told the judge, and he got very offended by, I think having that hearing does cast a shadow over this trial, unfortunately.
right. And to me, there seemed to be a Streisand effect that kind of underscored, the impulsiveness of Judge Glanville, because I think the ex parte in itself was so unusual, and criminal defense attorneys were outraged on it. The trial is already getting so much attention, but the jailing of the attorney, because granted, he did not ever actually spend the weekend in jail, but I think if you were in a newsroom arguing about the language that you could use, you would want to be strong and emphasize that he was detained for how long was it? I mean, he was back was he actually in a holding
I don't
cell?
know.
That's outrageous.
I didn't ask him where they took him when they took him in the back, but that is where the holding cells are.
Oh yeah, I mean, he was detained. He was in custody. He never actually had to go to the jail. He hasn't. I mean, and but that was all stayed. But you'd have to.
Brian was in custody.
Wow.
Right.
That's,
I think this whole situation is just unfortunate, and it didn't need to get to this point, but it just feels like the court is doubling down on their actions anytime they're given an opportunity to perhaps wind it back for whatever reason.
I would predict that he's definitely going to double down at this show cause hearing that happens, and it seems like the transcript review is kind of a setup for the big blow coming at the show cause hearing, but it just depends on what is the transcript actually say.
Yeah. And that, and also in that motion I mentioned that Caleb Bumpus's attorneys filed, they not only asked for him to be recused, it was also a motion to quash the show cause hearing, and he deferred ruling on that. And I don't know when he's going to rule on that. I mean, perhaps he's waiting until the start of the hearing to just summarily deny it. I don't know.
Okay, so he did defer, because it's confusing sometimes. Just even when you're watching the video, you have it at your fingertips. Because first I thought he was rejecting it, but then he goes back to deferring it. So he'll have to. He rejected
their motion to recuse him, and then he deferred, if I recall correctly, because that was my first day back after COVID, so I was in a bit of a fog. But he deferred. He deferred their motion to quash.
Okay.
Yeah.
So one thing I noticed, and you tweeted about this, was all the support that you've gotten from, other attorneys. And you had the declaration from Lester Tate, who also coincidentally, it just shows what a small world it is, like Steve Siddall representing Gunna, and then Donald Trump. Lester Tate was Judge Peterson's lawyer in the disciplinary proceedings, and this might get into work product stuff, but can you talk about how you linked up with them, and how that just kind of take people inside the sausage factory of the affidavits?
I think first of all, some background on Lester Tate. Lester Tate used to be on the JQC at one point in time on the Judicial Qualification Commission, and he seems to be the go-to guy if you're a judge and you're in front of the JQC, because he's a great lawyer. He's a great lawyer and he has experience. Yeah, so he's your go-to lawyer for that. And so I'll just, yeah, he reached out to me, as did a lot of lawyers offering their assistance. Um, and when Lester Tate reaches out to you and offers to provide you an affidavit on
Yeah.
a petition you're considering, you say yes as quickly as you can.
So just in my experience, that shows what a remarkable case this is. I mean, obviously it's live stream. You can watch it at your fingertips, but it seems like a lot of the times it's the attorneys who are on the case who are seeking out other attorneys to, write affidavits and give letters of support. Right?
In this instance, I've had, and I think I said this on Twitter, there's been attorneys from across the country that have reached out and offered their services, that have offered to do legal research or anything else that we might that might assist us. And it's all, this outpouring of support came in response to seeing what happened both with that ex parte hearing, that ex parte meeting with the witness and the prosecution. Because as you say, criminal lawyers were just gobsmacked by that, and highly offended.
Yeah.
I mean, I don't have enough adjectives to describe the way that criminal defense attorneys felt about that. And then to see Brian Steele, who is held in such high regard, be held in contempt, it was an explosion, not just in Georgia, but around the country.
Yeah.
And I think you covered that. Maybe we talked that day when, I mean, there must have been 30 attorneys that rushed down to the courtroom to show their support for Brian.
Yeah. Yeah. And I know I want to go back to a point you made earlier about you saw some points made in the Peterson ruling that could apply to Glanville. And while we've talked about the fact that he is, head and shoulders above Judge Peterson, and in this situation doesn't at all compare.
Not even close.
The thing that jumped out to me was that they said that she sentenced this defendant in front of her, or someone in a family law case or something, to 20 days in jail for contempt, with no legal reasoning or basis at all for first of all, even holding them in contempt, but then giving them the maximum penalty. I'm like, okay, that is absolutely what happened with Brian Steele. I mean, the judge was confused about civil and criminal the whole time because he wanted to jail Steele to make him tell him who told him about the meeting, but that would be a civil charge, as Ashley Merchant explained. So to then have that and go and give the max, is that the argument that you saw in the petition that stood out as being
parallel? I'll read you the line. I'll read you the line in the Supreme Court's opinion on, because I just pulled it up, Supreme Court's opinion on Judge Peterson, that I thought really kind of applied to what's happened in our case. And the Supreme Court says, engaging in or allowing ex parte communications presents to the public an image of a judge who covertly interacts with a party in order to unfairly advance that party's interests and jeopardizes the appearance of the independence, integrity, and impartiality of the judiciary. So if you don't think that's a quote that I believe applies in the present case, well, I think it does.
Yeah, I mean, the only time I've ever seen a judge recuse, actually in federal court, it was a big drama thing, but it was Judge David O. Carter, who might be known in Atlanta because he issued the January 6th rulings about John Eastman's emails and issued the rulings that said, Trump more likely than not committed crimes in the election fraud. But he was recused from a homeless case for mouthing off about some cities who eventually got sued. But at the time, they had not been named as defendants. And he had invited the city leaders to, voluntarily appear at the hearing, but then just made some cracks about how, they don't care about homelessness and they better hope that they don't get sued and end up in front of them. And then when they ended up getting sued and the case was in front of them, they hired Jones Day, which is, this big powerhouse law firm.
It's my old firm.
Recusal motion, and it was granted, but I mean, that caused a lot of consternation within the judiciary that he'd actually been recused. But it seems like that was an example of, and they cited it as appearance of bias. It's not just bias. You can think that the judge actually isn't biased, but it's just, this looks so bad. You're putting the judiciary in a bad public light. Is that the same standard that you were talking about there?
It pretty much is, this appearance issue. And I'm sure that Judge Glanville would tell you that he is not biased. I would bet, I can't go into his mind, but I would bet he believes he's not biased. But there's an appearance there, isn't there?
Yeah. Yeah.
And the actions that he took in having that meeting, not telling us about the meeting, doing everything he could to keep it a secret, keep the contents of the meeting a secret. You know, I think that I think there's a lot of problems there, and I think there may be some violations of the Judicial Code of Conduct here in Georgia, or the Code of Judicial Conduct in Georgia, with the way that that happened. And then I think that those issues were compounded when he failed to follow the rules on the recusal motion, which I believe were additional violations of the Code of Judicial Conduct. Of course, I'm just an attorney. I won't be the one that makes those decisions, but I'm certainly going to be arguing that. And again, it's just a shame we're at the point where we're at. I think that, of course, I'm biased, but I think that the attorneys in this case have been more than patient with what we've been seeing in that courtroom for a long time. And I guess we've reached the point where we need to act because our duties to our clients demand it.
And yeah, so to update the people who have joined us, you were saying that the judge is going to has a chance to respond to the petition that you filed. That's going to be the next step. Could we expect that in the next week? There has to be some kind of deadline for his response.
It's interesting on an emergency motion, which is the way that I've positioned this in the Supreme Court. There's not a deadline. The typical deadline is 10 days. On an emergency petition, there isn't a deadline, but it says something to the, and these aren't the exact rules of the Georgia Supreme Court, but it says something to the effect of as soon as possible, which to me would mean sooner than 10 days. He should respond. So we'll see. We'll see when he responds.
And so who represents the judge here? Does he have?
It's the State Attorney General's office.
Attorney General.
And so if you go to the Supreme Court website and you look at the docket for this case, it's got the name of the state AG and then another attorney in the office as representing Judge Glanville in this case. Okay,
so he's not going to be burning the midnight oil, writing this thing himself. Well, theoretically he could be, but it's going to have the names of the attorneys on it. Then he's not going to have to write his own. Hire his own lawyer.
I'm sure Judge Glanville is following the old advice of, not being your own attorney and would defer to I don't know, but I would guess he would defer to the AG's office because they have, and I'm sorry, I can't remember his name, but the other individual listed as representing Judge Glanville, not the actual state attorney general, but the other attorney that's listed. He represents judges on mandamus petitions whenever they come up. So he has a lot of experience in this. And I don't know how he'll reply. He may just reply and say that, well, I don't know, I'd be guessing. He could reply and say, I under the rules, it's not appropriate for the Supreme Court to hear it. Mr. Kendrick needs to file in Fulton. Or it may be, a more robust response. I'm just guessing. It's safe to say I refresh pretty frequently to see what's going on, and I haven't seen any movement. It'll be a week tomorrow, so we'll see.
So do you get notifications? Surely you must get notifications at the
next. Yeah, I'll get email notifications. Yeah, I get email notifications if anything happens.
Okay. Now, one thing that came up is Brian Steele has requested that he wants Jeffrey Young Thug to be able to attend the in-chambers meeting review of the transcript. Has anyone else made that request on behalf of their defendant, or is that Brian Steele's baby?
We have, I don't know if you've heard the judge refer to the Harvey rule in court. If you watch the stream, you'll see the judge say, well, the Harvey rule is in effect. Or sometimes one of us will ask, is the Harvey rule in effect? And that's named after Bruce Harvey. And it was started before this trial even began, I believe, when we were still in the motions phase. But basically, a standing rule that's been adopted in this case is any motion made on behalf of any defendant is automatically adopted by all defendants unless we opt out. So when Brian makes the motion that he wants his client to be there, that's treated by the court the same as all of us asking for our client to be there. That's one of the reasons you won't, if you're watching the trial and you see one defendant object, you won't see all the attorneys hop up and join, or when there's a motion, you won't see us all stand up and join. Sometimes we will as kind of a belt and suspenders thing, but just to be safe. But the Harvey rule, named after Bruce Harvey, applies. So we all have that same request.
Well, that's got to,
because we believe this is a critical stage of the proceeding, and under the Constitution, both Georgia and the U.S., our clients have a right to be there.
Yeah, and that's certainly got to save some time. The Harvey rule. It seems like one thing I've noticed as somebody who goes through the trial and puts together the clips is how long it takes to go through the exhibits. And is that just the way things done are in Fulton County, or is it specific to Judge Glanville? The way, if there's a photo, I mean, and it seems like they started doing them all at once now. You'll get all 10 photos you're going to go over and go up to the defendant and go over each one, so it gets entered as evidence. And then we start putting them on the screen. But it's like, Jesus, this whole process takes like 20, 25 minutes. It just seems like a huge waste. Like, is there something?
I think that's typical for Georgia. And the reason it's so, I don't know, clunky maybe in this case is just the volume of evidence. Is the big issue. And then, you have a number of defendants. Usually our interests are aligned, but not always. So we have to act in the interest of our client. And so, it can take a little longer. I mean, you got 6 defendants here. And the state, if you read my motion to try to speed this case up that I filed back in March, I cite the federal court in Kentucky where a judge opines about how, in every young lawyer's life, they lost a case because they failed to, put forth a witness maybe they should have, or they didn't put forward an exhibit that perhaps they should have. And so that makes attorneys cautious for the rest of our careers, where, okay, throw everything in. And then the judge in Kentucky said, this is a federal judge in Kentucky, says, in civil litigation, that's tempered by the costs associated with doing that. But in a criminal case where you have a prosecutor's office with unlimited, obviously not unlimited, but they have the public's resources. There's no check on that except for the court. So in this case is a prime example of that, where you have a prosecutor that originally wanted to call 700 witnesses. We spent a month on that incident back from 10 years ago of the fleeing car that went over the berm and into the side of the a month on that.
It was burgundy,
and that's just like one or two overt acts, and we spent a month on that. We have 190 overt acts in this case. So this case is going to take forever.
Have you noticed any kind of change in the? It seemed to me, as somebody who watches it every day, that things were kind of picking up a little bit. I mean, there was that day where you had all the barbershop witnesses. I'm like, wow, they're actually making some progress here. But then everything just came to a screeching halt with this Woody stuff. But I've seen maybe that it's a nice example of the unity amongst the defense. Like you said, you have separate interests because you have separate clients, but it seems like you guys are working together pretty well on this. I mean, Max is kind of taking the lead on a lot of the argument. We saw Keith Adams arguing today. Has there been much disagreement within the defense on what exactly gets shown?
We haven't really had any significant disagreement, really. I mean, pretty much we've been able to come to agreement on virtually everything. I would have trouble thinking of something where we were at loggerheads, and that was an issue that we had to bring up in court. Pretty much, in general, our interests are aligned, so we're able to come to agreement on a strategy for each of the witnesses, for how we're going to approach certain exhibits. And actually, I think the fact that we're coordinating so much, it would be much less smooth if we weren't talking offline, trying to coordinate this. So different attorneys will take leads in different areas to try to, at least on our side, we're trying to make it move because our clients are locked up. Let's get this over with.
So what are we going to see first? A Supreme Court ruling or Woody back on the stand? It's hard to say. It's possible to say.
Well, I guess Woody is due, Mr. Copeland is due back on the stand July 8th, I believe, right now.
Yeah.
I would think before July 8th, I will hear something from the Georgia Supreme Court, one way or the other.
Would you say you're on track or ahead of schedule in terms of going through everything? I mean, they have how many jail phone calls to go through? It's like 2.5 hours of jail phone calls, and they got through one today, but you've got a couple more days. You're done.
Yeah,
for
we'll
the
be
week.
able to. Yeah, we're done for the week. No court Thursday or Friday. I think we'll be able to finish up those jail phone calls on Tuesday. So I don't see any reason that they won't get to Mr. Copeland on the 8th. Of course, one of the reasons that I cited as an emergency for my petition to the Supreme Court is I think this needs to be resolved before Mr. Copeland gets back on the stand. Right. Because we're going to be in a situation where there very well could be questions put to Mr. Copeland regarding what happened at that ex parte meeting. And then I would expect objections from the state. And then you've got Judge Glanville. You're going to have objections from the state, from attorneys who were witnesses to that meeting. You're going to have a judge who was a witness to that meeting ruling on the objections. So, I think we need to get this recusal thing straightened out before Mr. Copeland gets back on the stand, to
right,
me at least.
It goes beyond just the fact that you want the transcript from the hearing, because it sounds like it's possible you could have the concern about the transcript alleviated on Monday, just depending on what you see and how much is redacted. But as you said, this goes way beyond the transcript. It goes to the conflict of interest that people now have in the courtroom, because there was this not only the ex parte hearing, but now there's this ongoing contempt proceeding and everything related to it, witnesses and that, right?
And just to be clear, there's no conflict involving the defense attorneys. I think to the extent there's a conflict, it involves the judge and the state.
The prosecutors who were in attendance at the meeting, right?
Right, and who will be the same. One of those is the same prosecutor that has been in charge of Mr. Copeland's testimony. I think we just need to get this resolved before he gets back on. The other thing is, what happens if the judge is recused?
That would be crazy.
There's.
That should be my question to you. Because you, as somebody, as a practicing attorney in Georgia, my theory is the case would be on hold and it would be randomly assigned to another judge in Fulton County, and then you guys would have to start all over. This jury would go away, and am I right?
It feels like there should be a mistrial if the judge is recused, because in general, I believe, as I've seen it, what should happen on a recusal is you bring in another judge, and then you rewind the case to the point where the motion for recusal was initially brought, which would be 2 weeks ago. But I don't know how you unwind the testimony that the jury heard from Mr. Copeland. How do you unwind that from the jury's mind?
Yeah. And is it common practice, and I don't think it's common practice anywhere, for a trial to just stop midway and another judge to just take over? It seems like kind of.
I don't think that's not common practice. No.
Would restart, but is it standard practice in Fulton County for one judge will have the case in the very beginning and do the preliminary hearing or something, and then it could transfer maybe even on the day of motion practice to another judge? Or that's how they do it in LA with Superior.
Yeah, I think when you mean, is that normal practice absent a recusal?
Yeah, absent a recusal. Do you have judges kind of passing cases around like that, early stage to late stage?
No. A judge will hear it from beginning to end. So switching judges midstream is unusual and really only happens in rare circumstances like a recusal. But this case is it's hard to fit certain case law on, because it's just not contemplated that you're going to have a trial that takes years. And we've been in trial for 18 months. So it's in a way, it's sui generis.
And it seems like, and we see Bruce Harvey doing this with this kind of standard objection to, he wants a gosh, what's the
A limiting instruction, a Rule
a
105
limiting
instruction.
Yes, the 105 instruction that he always asks for. And it's the prejudice of having all this coming in kind of a co-conspirator light like this. And I don't think I've ever seen an appeal that just says this case was way too big. But it seems like this case gets into the realm of this could just be declared unconstitutional, basically just based on the fact that the case is way too big and the trial lasted like 3 years. Is that possible, or do you think that the appeal is going to be more detailed or refined?
I think the appeal, should we have to go to appeal, will be more sophisticated and complex than that. But there's so many. We believe. I'll say I believe, and I'm sure the other defense attorneys wouldn't disagree. There have been so many errors in this case already that it just feels ripe for appeal. But I don't want to. I mean, I want to win now. I want my client to, I want a fair trial. I think a fair trial would result in a not guilty verdict for Mr. Kendrick, and then he can go home. It gives me no joy setting up things for appeal and we lose. And this appeal is going to take years that Mr. Kendrick would be sitting in prison. And the judge from the bench says, well, we'll let an appeal court decide that, and I can live with their answer. I have a different attitude.
For the people watching, there's only an appeal if there's a conviction and then a judgment. If the jury comes back and acquits on all charges, then there's not an appellate process that you go to. And
right.
Remember when we talked last time, you were saying that's your end game right now. You don't. I mean, while you're asking for a mistrial, that's part of the litigation process and part of the trial process. Your end game here is an acquittal, and that hasn't changed, right?
No, that's absolutely the end game, and I mean that's what we're fighting for.
Yeah.
An acquittal after a fair trial, and I think we're at the point now where we're not getting a fair trial.
Yeah. Has anything changed since the petition has been filed? I mean, I've just kind of noticed that Glanville really seems to be in his element when he's doing this stuff, taking forever to go through all these evidentiary stuff. And he's kind of cheerfully hearing from both sides. If anybody has anything to say, they can always come up. I mean, he really seems to be in his element. Is he just being nicer to you guys, or does he just like doing this stuff and he's always kind of like that when he does this law enforcement?
In general, he's usually very cordial to all parties in his courtroom. I think here we have a situation where the process this week is being driven by Miss Hilton, ADA Hilton, who is very professional, courteous. We have a good relationship, I think, with her. And so this is how a normal trial is. So we're able to work together. We talk about things. We reach agreements that certain things, are going to be left off. It's just very professional, courteous. It's flowing very nicely. And it's a nice break from the way things have been. And I do think Judge Glanville from the bench does appear to enjoy tackling these issues that we're bringing before him on whether certain statements and these interviews can come in or not. I don't want to say that the petition has changed him, because I don't think it really has. I admire that he has not in any way, and my petition was harsh, but Judge Glanville has not in any way taken out what I said in my petition on me in court. He's maintained the same courtesies he's always extended to me. He even inquired about my health when I was there on, I guess, last Friday, which was the day after the petition was filed. He's not cold or icy to me.
And there's always kind of a saying that, if you go after the king like this, you better make sure you take him down. But are you actually worried about that? That if for some reason the court rejects this, he's going to go after you personally? The problem is not that he's going to seek revenge. It's just that the behavior that you complained about in the petition that's a problem is just going to continue. Is that accurate?
If we were to for whatever reason, not get him recused from the case and he were to continue to hear the case, I don't think his behavior toward us will change one way or the other. At least based on what I see this week. So I would expect that to be, I don't know that it would get any better, or that the bias that we see would be removed. In a way, we've kind of put him on notice, perhaps. But, I believe Brian has requested his recusal and mistrials. This wasn't the first time, I don't believe. And Brian's repeatedly requested mistrials based on what's happened in the court.
Yeah.
So we'll see. I don't know. I don't like to forecast, but given his professional demeanor toward us this week, I would expect him to just maintain.
Yeah, because I'm very interested to read whatever written response there is from the state attorney general's office. But it seems like the judge kind of previewed or said what his defense is when he was rejecting this motion. And it seems like he is arguing that he thinks he views this ex parte meeting, although it's unusual, unheard of, perhaps, it's still just a move that he made as a trial judge and nothing that shows like a personal bias or something like him, mouthing off about the defendants or something like that. I mean, are you anticipating that as a defense here?
Probably, perhaps, but the how would I put it? What I've argued in that petition and in my motion to recuse is very specific. It's not necessarily the substance of the meeting as much as it is the fact that the meeting occurred, the fact that we weren't put on notice, and then how he handled the motion to recuse are all in violation of the rules. And so therefore, it's a very targeted attack. And I don't see how, I'm sure, a good attorney will work hard to rebut that, but I don't know how you refute that he did violate the rules.
Yes. That's why I think we're all kind of on pins and needles now, knowing that there's going to be a filing that they'll actually respond to. There's no chance there's going to be a hearing on this, right? Like the Supreme Court hears everything on the merits. There's no chance of oral argument, or because they're the state Supreme Court, if they wanted to hear oral argument, because
it's all up to the Supreme Court, and I'll do whatever they ask. And that's like, let's say that the petition is granted, either in Fulton or at the Supreme Court. And then there is another judge that has to consider the recusal. That other judge can consider the recusal just on the paper. That other judge could have a hearing where he hears from witnesses. That other judge has a lot of flexibility on how he handles the recusal motion.
Interesting.
So you could have this whole little side trial, almost side hearing, just on recusal.
Right.
And
for everybody watching, to be clear, that's what the Supreme Court is before them right now, is not should the Supreme Court recuse Judge Glanville. It's should the Supreme Court order Judge Glanville to send his recusal motion to another judge. That's kind of one of the main issues that they're dealing with here, which obviously could lead to this other judge then recusing Judge Glanville. But that's a whole nother step here.
And I would think I would hope if the Supreme Court takes the extraordinary step of hearing my petition and then ruling in favor of my petition by granting a writ of mandamus, that would carry some weight with whatever judge has to hear the actual motion for recusal. I don't know.
And somebody asked in the comments if it's possible for the prosecutors to get recused. And while that's not on the table now, I mean, that's the way to kill the case. That's what we saw in with the Fonnie Willis recusal. And then that just happened. I don't know Georgia criminal cases enough, but there's another RICO case that they just moved to recuse this attorney general's office. And that's the kind of fatal blow where, yes, if the Fulton County District Attorney's Office was recused from this, theoretically, they could just go get another prosecutor's office and try to get somebody to do it. But the odds of that happening in a big case like this are none. But has there ever been any talk about trying to get the prosecutors recused? Has there been an effort to get them recused?
I'm not going to discuss what the defense attorneys have talked about amongst themselves. Sure. We haven't filed any motions to that effect. I haven't filed any motions to that effect right now, or petitions to try to get them recused. We'll see. I mean, the problem, of course, now is they're witnesses, right? They're witnesses to that ex parte meeting that took place. So wait and see, and we'll see what happens.
Yeah. So then again, to remind everybody, that's what's on deck next week. In addition to the 4th of July, we've got the Chambers hearing Monday morning, which obviously that's not going to be available for us to watch. But then Wednesday is the show cause hearing, and we can expect all the defendants to be in attendance at that. Would you say that's correct?
Right. At the show cause, yeah, I believe that we will be at the show cause hearing. Okay. We'll see if he brings them over for that. And again, he hasn't ruled on the motion to quash the show cause hearing, but I expect that he's going to deny that. Yeah.
Thugger Daily asked, surely the entire office wouldn't be used, just the individual prosecutors. I mean, it would depend on what the basis for recusal was, but in the motions that I've seen, at least in Orange County, it wasn't the top DA, unlike the Fonnie Willis recusal thing in the Trump case. It wasn't the top DA's personal conduct that was at issue, but it still got the entire office recused from it because of all the law.
I'm just not going to weigh in. Yeah, I'm not going to weigh into that because I don't really have an issue talking about motions or petitions that have already filed, but I don't want to get into things that could even remotely be filed in the future, and what we might argue or where we might go with that.
Yeah, no, I think that's fair because you guys have really a long ways to go. I mean, this is a strategy game that you guys are playing kind of nonstop. I commented to you the other night about how much it just must suck to never know when your breaks are, to not only have the schedule not set, but even when you have the schedule set that day in court. I mean, it's not like, oh, I know there's going to be a break at 10:30. You just have no idea. But how's everybody holding up? It seems like the entire courtroom's sick.
Well, I think I'm the only one that was ill last week. I don't think anyone else is. There's a few coughs, but I think we're doing okay. But it does make it hard to plan because what happens is all of us have other cases in other courts, and all those cases are held up. But those judges, some of them pay attention to when Judge Glanville says he's going to have a break. And then they clamor for our time. They'll say, well, Mr. Weinstein, I know that the judge isn't going to be having court Thursday and Friday. So, for example, we were not supposed to have court today originally. A few weeks ago, this day was supposed to be an off day. So I was scheduled to be in about 3 different courts today. And when I found out this week, we had to go to the YSL case, that had to be rescheduled. So it's very difficult. It's very difficult in planning our lives to kind of not know. He's been doing, since we've seated a jury back in around Thanksgiving, he's been doing a better job of giving us some advance notice of when we have some breaks, which we really weren't getting before. And that's helpful, except for the fact that he'll make last minute changes. So if you remember the week before Memorial Day, that whole week was supposed to be off for the jury and for the attorneys. And then the Friday before, literally the business day before, he said, oh, we're coming in on Monday because the hearing or whatever I had that day has been canceled and we need to be efficient. So everybody has to come in on Monday. And there were some noticeable groans from the jurors.
Are the court report? I mean, is the court staff unionized? I mean, is the thought is that these people are just never going to take vacation for the next 3 years, or are we going to see a sub in for Chris, the court reporter
for Miss Weaver?
Yes.
I don't know. I mean, we do have breaks. Like I think we had a break like last Christmas. There was a break in April where the jurors wanted to take a spring break. So they kind of, I don't know how they decided, but they like proposed a certain week that they wanted to take off. So we do have breaks, and we do have some notice of them when they occur. So it's fun. We're all holding up pretty well considering how long we've been in trial.
Yeah. Huh. Well, what's coming up? I mean, is it the thought that Woody is just going to take the month of July? Is this the summer of Woody? I mean, July, that actually might be a conservative estimate. Could be a lot longer.
I'm guessing maybe a few more days of direct of Mr. Copeland. I don't know, 3 or 4 days of Mr. Copeland direct, but then we have our cross-examination of him. So
That should be.
I can't tell you how long that will be, because we're all working on that right now.
Yeah, and we can expect probably pretty lengthy questions from Max, and Brian Steele's doing the cross. He's made clear a bit. One thing I've noticed is, I mean, we've heard so much about Shannon Stillwell, it seems like, from Kenneth Copeland, because obviously they were really good friends. I mean, we haven't heard all that much about your client, and he's one of the ones actually charged in the murder too, alongside Shannon. I mean, are you expecting that to change, or?
Well, I think that I'm trying to think just a moment. I think that when they play some of the interview tapes, that you'll hear my client's name come up a little more. Maybe not to the same extent that Mr. Stillwell's name has come up, but you will hear my client's name a little more in some of the interviews. But I don't really credit much of anything that Mr. Copeland has to say, given his testimony on the stand, which is that he pretty much just said whatever he needed to say to not go to jail. He really did not want to go to jail.
I mean, it
which I get. I wouldn't want to go to Rice Street either.
Yeah. It seems to me that even if he said right now, oh, yeah, I remember those interviews and I said all that, I was telling the truth, could they really just believe every single word he said? I mean, it seems like this case just rides on the jury believing every single word that's said in these police interrogations, or at least the ones that are played to them. I mean, and not just with Woody, but with DK, with Tick, or was Tick? Yeah, we didn't hear
Stevens.
Hear much of that, but.
There's the problem is that when the state's witnesses get on the stand, they're not testifying the way the state would like them to testify, and so then they play these tapes, and so you've got to kind of figure out, how much credibility the jury is going to attach to what comes up in these police interviews.
Has there ever been any discussion, because lately Max Shard especially has brought up the fact that, in Brian Steele too, that there's no evidence of any kind of intimidation by your clients, the defendants, against Woody. But it seems to me the elephant in the room is not just, you can't name a single person. It's like the internet masses, And when they say, well, Woody doesn't want to get labeled a snitch, it's not Young Thug that I think he's really worried about being labeled a snitch. It's the internet masses. Has there ever been a talk about what would happen? Well, I mean, if prosecutors tried to bring that up, it seems like an unorthodox thing to mention to the jury that, hey, by the way, this trial is being streamed to hundreds of thousands of people. Is there any thought that could ever come up?
Well, I would hope not. And there's been as you say, there's been no evidence, and I haven't seen anything that Mr. Copeland has been intimidated, threatened in any way by any of the people on trial right now. And look at his social media. Does that look like somebody that's afraid while he's lounging in the pool?
Oh yeah. He's got his kids out in public places. He's not afraid.
I mean, he's living his best life.
Yeah.
So he doesn't appear to be concerned.
No. Well, and that's all stuff that can come up on cross-examination, like Judge Glanville has said. I mean, I'm anticipating questions about that, to counter any kind of implication that he's been intimidated could we see these social media posts that are coming up? Well, you don't want to preview stuff.
I'm not gonna address what we haven't done yet.
Sure.
And certainly not address any conversations amongst defense counsel. But
Sure.
I mean, I think you can imagine the types of questions that we'll have for Mr. Copeland.
Yeah.
And I always have to also keep in mind that we have seen things that the public hasn't. So, for example, well, I guess at this point you have. At this point, they've been streaming this week, right? So you've seen the Copeland. Okay, well, that's the extent that my client's name is going to come up, with Mr. Copeland. And, it may come up a minimal amount of time with some other witnesses. I don't know. But it's clear. I mean, Mr. Copeland's testimony, he told the police what he needed to tell them, to what he thought they wanted to hear to save himself.
Well, it's funny that they're just so scrambling that this happened. The prosecutors clearly were not prepared for this. And it's like, oh, yeah, who would have thought this would have happened in this trial? Of course he did that. I mean,
I'm not going to speak to the preparedness of the state. They've had a number of witnesses before Mr. Copeland get on the stand and not testify the way they wanted them to, and they've been impeaching their own witnesses since December or January. So I don't quite know why they would expect Mr. Copeland to be any different. It's a question for them when this is all over.
Where are we in the testimony about the Donovan Thomas murder? Because we still need to hear from Rich Homie Quan. Do we have a long ways to go after Woody, or are we going to be wrapping up the testimony,
that's up to the, that's kind of up to the state. I don't know how much they're going to keep putting on as far as the Donovan Thomas murder goes. But I could see it going through a good piece of July, certainly a few weeks, if not all of July. But I can't. I don't know what they're going to do with that murder.
Yeah,
it'll be interesting to watch.
2 others charged in here, correct? We've got two other separate murders that we'll hear about later on.
Yeah, and none of my client is not accused of being involved in any way of those murders. So that's a piece of the elephant that I haven't paid a lot of attention to.
Okay.
But yeah, but I guess if your point is, if you thought the Donovan Thomas murder took a while, yeah, we have additional murders that at least one of them hasn't been tried at all. So we're going to have a similar time period on that. And I know people thought that my 2027 estimate was 700 witnesses or 400 or whatever the number was. May have been exaggeration, but look at how this case has been going. Yeah. I mean, we're not even halfway through with the state's case.
Wow. Yeah, no, I'd say it was almost, if anything, it was a conservative estimate. It's going to be longer than that. But...
Yeah, my current guess is my current guess is spring to summer of next year. So.
Yeah.
Because they are down to 200 witnesses. So.
Yeah. Well, and now how's everybody? How's everybody doing? I mean, it's just been wild to watch, but then you think about the defendants who are actually sitting there in jail, and it's like at one point, God, their lawyers are starting to get jailed too. Is this a morale? Is this hurting morale amongst the defendants? Or
no, I would say, if anything,
more inspired.
That invigorated. Yeah, I would say that. The contempt, between the ex parte hearing and the holding of Brian Steele in contempt, it really has rallied us and injected new energy. We were plenty energetic before, don't get me wrong, but this has not been demoralizing in the least. It's been, oh my gosh, this has gone, for me, this case has taken a significant turn and it needs to be fixed right away.
Yeah.
Again, I'm I'm not looking for shortcuts. All I've ever wanted for my client, all we've ever wanted for our client, myself, Jay App, Katie Hingerty, is a fair trial, because we're confident. Give us a fair trial, we'll have a not guilty verdict. So let's go. Let's get there. Let's move it. Let's get him out of jail. Let's get him home to his family. So I'm not doing this. There's no glee in my having to file a motion to recuse and a petition to the Supreme Court. There's no joy there. This is not the trial that we wanted.
Yeah, it just seems like it's reached what Brian Steele said maybe more than a month ago now, that this trial has gone south, but it does seem like it's just the inherent problem is it's too big, and there's all these problems that just kind of stem from that we're seeing now. But
yeah, I mean, we had 28 defendants in the indictment. It would have been handled, talk about federal versus state court. This would have been handled completely differently in a federal court. It would have been broken up into manageable chunks. You wouldn't have been trying all defendants in the same trial. I mean, we're down to 6, but we didn't start trial with 6. We started trial with 14.
Wow.
It's just through pleading, through severance, various things that have happened in the court. A couple of attorneys get pregnant. So it's down to 6, but a federal court would not have handled this case the same way. I imagine perhaps some other judges wouldn't have handled the case this way. I don't know.
Yeah. Can you say how many defendants are still in jail awaiting trial? I mean, there's 28 total, but how many have taken plea deals? Person who probably knows. I don't. I have it on a piece of paper somewhere, but not where I can bring it right back in front of me. Yeah, because it sounds like there's a chance that, I mean, you guys would just get wind of any plea offers to other defendants just if the other attorneys were telling you about them, right? It's not like you're under no obligation to be notified. Oh,
no, they don't have to notify us of plea offers to other defendants.
Okay.
And we don't have to notify each other if we get a plea offer.
Okay, right.
I think Thugger Daly just answered. Thugger Daly just answered the question.
The answer is 8. The answer is 8 plus 1 on bond. Okay, who's on bond?
Oh, you know who's on bond? It's Mr. Menendez's client, whose name escapes me at the moment. I believe he got $1 million bond. I don't even know how he got scooped up in this. Miles Farley. There you go. That's Mr. Menendez's client. He got, I believe, $1 million bond, which Thugger Daly can confirm, since he has a greater grasp on the entirety of this case than I do, I think.
Well,
he or she, I should say.
Like I said, I think Glanville's a kind of a victim of his own Streisand effect here, where he was upset that people found out about that ex-party ruling. So he took an action that made it so a lot more people found out about the ex-party, not the ruling, but the meeting that he had. But it's not so much the meeting that got everyone's attention. It was the jailing of Brian Steele for contempt. And I actually, when I wrote the Substack on it, there's a retired federal judge who subscribes, and he's old, so he doesn't know how to use email. And when he hit reply, he meant to send it to a friend, but the friend's name starts with M. So he accidentally sent it to me, and it said, so-and-so, this is the case that you were telling me about. I'm like, yeah, everyone is talking about this. I think a lot of people are talking about the ex-party, but the contempt jailing was just like, okay, this is insane. What's going on with this? Like, how do you come back from that? I think that's the point you made in your petition. Well, the contempt is kind of Brian's thing.
The contempt is Brian's thing, right? And Brian brought it up in his motion, I believe, when he filed his motion to recuse. By the way, as far as I'm concerned, I don't believe the judge followed the rules in handling Caleb Bumpus's motion to recuse or Brian Steele's motion to recuse. I mean, it's a very clear process in the rules of what is supposed to happen. I don't believe it happened.
And you believe, absent of that, you believe the recusal, but the petition still stands just based on the ex-party. But it seems like by calling this contempt hearing and then basically making himself a witness. He's kind of exasperated it, has he?
I believe that there have been multiple opportunities to make things better versus making things worse. I think we lost you.
Oh yeah, sorry. Sorry, I had to kind of clear my throat there a little bit. Man,
okay. Anyway, yeah, I think that there have been several opportunities to walk this back. The judge could maybe walk it back a little bit, or dial it down, perhaps. Maybe he could say the same for us, and we could have dialed it down. But we have an obligation to our clients, and I didn't see where I had an option but to file a motion to recuse. And then I didn't believe I had an option but to file a petition for a writ of mandamus. No attorney enjoys getting into a fight with the judge, any judge, or having to say, I don't want to say bad things about any attorney or judge. I really don't. In civil practice, I would often have to file motions for sanctions, and they were a last resort. And again, there was no joy in seeking sanctions against a fellow member of the bar, and I have no joy in seeking Judge Glanville's recusal.
Right. Well, what didn't we cover that you think should be addressed? Is there anything else you want to say?
I think the thing we haven't covered is my need for sleep. So.
Oh yeah, yeah.
No. I can't. We can talk again later as this develops. And sure. Again, I'll be happy to talk about things that have occurred in the past once those things come to pass. But tomorrow I have a 2.5-hour drive to court somewhere in South Central Georgia.
These are your other cases, obviously.
Yeah, right. So, and that's the thing that people have to understand that are watching this. All of us attorneys, maybe not the state, but the defense attorneys, we have other clients, and we have duties to those other clients, and there's things that we have to do. So when we're not in court, one of two things are happening. Either we are doing work in preparation for an upcoming witness in YSL, or we're handling matters for other clients that are getting stacked up. So that's what I'll be doing Thursday and Friday.
Well, hopefully you're able to take some time off for the 4th of July.
Well, yeah, I think so, perhaps. And I was able to take a few minutes to watch the Hawks draft pick today. So.
Okay, great. Well.
All right.
Great. Well, hey, thank you so much for joining us. Your insight is always so much appreciated, and I know everyone really appreciates it in the comments. So
thank you for inviting me on.
Yeah.
I think it's important to educate the public, and you're doing a great job of doing that. And to the extent that I can do that in keeping with my ethical obligations, I'm happy to do that as well.
Great. Well, Thank you so much. We'll try to do this again soon.
Great. Take care. Bye.
Thank you. All right, there we go. I coughed it out, guys, I promise. Gosh, I just looked up and again, we've been talking for 83 minutes. I'm good now. Got the bug off my throat. But I sit here in this apartment. I'm like, man, I got to turn the AC on. It's getting a little hot in here. But, new apartment. I just moved in here like a couple months ago. You're kind of still getting used to how things are in here, but it's good. But yeah, wow, I didn't expect him to have that much time to talk with us. But I don't know if everyone's actually seen the petition that he filed. I didn't want to bring it up on the screen just because it's the kind of thing that we can bring up when he's not available to talk. But he filed it here. Let me see. I've got it on document cloud for you. Bringing it up now. But we can just kind of see it and go over it here. I thought that was interesting that I'm obviously eagerly anticipating that. I don't think we'll see it maybe until after the 4th of July. I don't know, maybe before that. Maybe they're working on it right now. But the fact that he's going to respond to that. There's going to be a response from the AG's office filed against that petition, arguing why the judge shouldn't be or not that he not arguing that he shouldn't be kicked off, but arguing against the request. Maybe they'll argue that he shouldn't be kicked off, but they're going to argue that this motion was properly rejected and it should not be sent to another judge for consideration. Because it is possible that the Supreme Court, I kind of think they're going to reject it, but it is possible that they send it to another judge and then that judge rejects it, but he also could grant it. You just don't know. But yeah, everybody hit the like button. I saw somebody urging that in there, and that would be great. The channel's coming along. I like doing the clips for you guys. The discussions right now are a little harder to go through because I mean Glanville, he's in his element when he does this stuff. He loves just taking forever to hear all these arguments and listen to the recordings over and over and over again. But it's always interesting when they actually play the recordings, and I try to clip that stuff for you guys. But let me see here. So yeah, it's 83 pages, but the actual meat petition is 24 pages, and then the other 59 are like exhibits and well, things like that. But here, let me link to it in the comments, and you guys can have at it here. But yeah, that's interesting to me that, and it's not that Glanville has like personal attorneys. It's the Attorney General's office would do this for any judge in a situation like this. But here, let me. Okay. All right. We're going through the petition here. Anyway, I linked to it in there. I've got it linked and explained in an article too that's I think actually embedded down below. But I think I am going to sign off here pretty soon. We'll just go through it real quick. There it is. Serious breaches of the Georgia Code of Judicial Conduct relates to conduct of Judge Glanville. Remember, this is Weinstein's petition in his co-counsels. So it's all about the ex parte, whereas Wen Steele, I'm assuming, is going to file a similar petition because his recusal motion was granted. I think we're going to be hearing a lot about the contempt ruling in that petition, but that's kind of his separate thing. But Glanville's court is where writs go to die. And this is what he discussed earlier, that while there's technically a process where this would go to Fulton County, and there is a chance that the court, instead of issuing a ruling, could direct them to do that, they explain in here why that would have been a waste of time. That it would have just been rejected, and that he's not he's not a non-biased rejectee. But yeah, it goes through the ex parte. Somebody corrected me in the comments. But Bill has a unique position within the county, which carries a significant amount of weight and power among his fellow county judges. Repeatedly refused to issue a certificate of immediate review. If not considered by this honorable court, the still incarcerated defendant would be forced to wait for at least another year or more of trial before seeking appellate review. True. The appellate procedure in the case at bar will be extremely lengthy and cumbersome with more than a year's worth of transcripts to review. Yeah, no, it's going to be crazy. They're talking about witness was coerced by Glanville, presently on the stand. We know what's going on with that. Tentatively due back July 8th. That could change, but right now it's July 8th. To have been filed and presented in a timely fashion. Oh, sorry. Somebody's doing the wrong comment. Somebody asked if I think they're going to reject the motion to recuse Judge Glanville. So right now, the issue before the Supreme Court isn't to recuse Judge Glanville. It's whether the recusal motion that he rejected should be sent to another judge for consideration. If I was forced to make a bet on this, I would say that the court isn't going to intervene in this and order that. But also Glanville might have screwed himself over in his own order, because according to Georgia state law, if they find that the pleadings are just sufficient on their face, he has to do that. And he basically wrote in his order that they're sufficient on their face. But then he went on to say, but there's no evidence. And the point in the petition is there's no evidence because the transcript is evidence and they don't have the transcript. So when I read that, I'm like, I wonder if he kind of tied the court's hands here and they're going to have to send it to somebody else. But I don't know what they're going to do. See, what I've noticed in covering cases, I cover a ton of different cases, but everybody just expects you to say whether a ruling was good or bad, whether somebody's going to win or not. It's just like, dude, it's a little more complicated than that. But it's not really what I'm here to do. But yeah. Who's this guy that keeps commenting on my appearance? It's gross, dude. Ban him or something. The transcripts gets redacted. How could they find out everything that was said at the meeting? Yeah, I mean, it's a big remain to be seen about what is this transcript going to look like, and what are the redactions what are they going to see when they walk into chambers on Monday? Is it just going to be a whole unredacted transcript, or are there going to be redactions, or what? And how much will that quell their concerns about this? But as we talked about earlier with Weinstein, it's not just the transcript that they're worried about. It's the conflict of interest that's been created by this whole thing. When there's participants in that meeting, the prosecutors and the judge, prosecutors are presumably going to be making objections when there are questions about that meeting. The person who's ruling on the objections is going to be another person who is in that meeting. It's kind of a cluster. Kind of a cluster. But it is hard to recuse judges. That typically is a very difficult standard. But I think Doug Weinstein went over that. And this is exactly what they want. So you notice it doesn't say that they're asking the court to order he be removed from the case. They're asking the court order him to produce the transcript and ask the court to enter any further writs or orders it deems appropriate given the actions of Glanville. So that's kind of an open-ended call for them to do something. But their main request is right here. Adhere to Rule 25.3, which is the Georgia state rule that says that if the pleading a recusal motion like this, the allegations are fine on their face or enough on their face, then it needs to be sent to another judge for assignment. So that's the main crux of what they're asking for here. Anyway, what else we got here? Issues presented, whether he was correct to follow the mandates by refusing for the motion to recusal. God, it's crazy. Nearly 18 months ago. Because when they say January 2023, they're talking about jury selection. Because technically a trial begins when jury selection begins. So, yeah, we're already 18 months into this secret ex parte meeting. We've heard about that. Also presented sworn was printout of certain, yeah, and I've got an article link that kind of goes over this. I gotta actually kind of run and get some dinner here. I've been on a little longer than I planned, but I'll go through the end of it here. As follows, this party. We had Glanville, Copeland, security staff. I mean, because remember, this was when Copeland was in custody, so they had an inmate in a judge's chambers. It kind of course, they just overdid it. They probably had like 8 deputies there. They all find out about it. Yeah. See, I think in Steele's petition, we're going to be hearing a lot more about this contempt finding. Maybe, but we'll wait until that. We'll let him write that. 3 motions to recuse. Because then there was Thugger and then Caleb Bumpus, the attorney for Caleb Bumpus. Argument and citations to authority. Here we go. Glanville has failed to follow the rules. This is them citing the... and I want to look up this case. Some civil case involving Magnolia Advanced Materials that became binding case law about judge recusals in Georgia. I'm sure it's a reader. I'm going to do that tonight. People wondering. I got people texting me. Hold on. Wondering where I am. Yeah, I got to go. While Glanville's views appear to be evolving over time, Glanville has recently indicated he may provide a redacted transcript of the proceeding prior to Copeland's cross-examination. So that, obviously, this was written a while ago, and that is what is happening on Monday. But remains to be seen how satisfactory the production of that transcript will be to their concerns here. Glanville has violated multiple rules. Down with Judge Glanville, failed to notify. And that's what I've heard from everybody. Like this court clerk that I've known forever, and she's never clerked in Georgia, but she was in California federal courts and California state courts. She said he definitely should not have done this, but he definitely should have notified them about it. Like if he was going to do it, he had to notify the defense about it. So she was kind of appalled at that whole thing. But again, I think it comes down to, I just feel like the court, I could see other judges or the Supreme Court, the argument from Glanville is going to be that while this was unusual or appears unusual or blah, 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 it doesn't show a personal bias. It means it's just a trial decision by a judge. And, it should be reviewed on appeal. I'm anticipating that's going to be his defense. It's going to be a lot harder for him to have that defense to the contempt finding, the whole contempt issue with Steele. But I don't know. We'll see. Where am I here? And this is the, here we go. Here's the petition. That's the end. And then these are all their exhibits. So what is that? We're on page 31 of 83, and then 52 pages of exhibits here, which is the original motion to recuse. It's got his order in there, et cetera, et cetera, et cetera. So anyway, thank you guys so much for tuning in. Again, I've got that linked in the chat. And then if you go to my website, legalaffairsandtrials.com, it's like right in the center, there's a story on, it's got Woody's picture, and it talks about the review of Woody's police interviews that's going on. But if you scroll through, it's got a link to the recusal documents, and you can watch some videos about what's going on with that. So, hey, thank you so much, everybody, for tuning in. Coco, thanks for saying hi, and thanks for saying thank you. You are welcome. And let me see. I feel like I don't want to miss any questions or anything, but it seems like everybody's just kind of chatting. I don't feel like I've missed any big questions. Yeah, thank you so much. Go get dinner and mess. We appreciate you so much. That's one exciting thing about moving to a new place. You've got all these new options. go all over downtown LA. Go take one of those Lime scooters out or something. But anyway, thank you guys so much. I will try to do this again when we've got some news on this. Definitely when the response is filed, I'll do the Attorney General's defense of Glanville, opposition to this whole thing. That'll be a good read. And then when there's a final ruling on this and we, get some closure or whatever, hopefully Doug will be able to join us again. And then also I'll try to be a little ambitious here about my lawyer interviews. I mean, let's try to get Brian Steele or Keith Adams on here. That would be great. Or Max Shard or somebody like that, or Angela D. Williams or somebody. But that would be great. So thank you guys so much for tuning in. Your support is everything. Hit the like, give me a subscribe, and then go to my channel because I've got tons of video clips on there, and I like the way I've organized it. It's kind of the most challenging thing is how do I organize those clips for people to watch and not just get overwhelmed by like, what is all this stuff? So if you go there, I've got to my channel, I've got playlists for legal arguments, Woody's testimony, Brian Steele held in contempt, that kind of thing. So yeah, we'll try to get everybody, but anyway, thank you all so much. Have a great weekend. If I don't do this again before the 4th of July, try to get out there and have some fun. So see you guys later. Thank you.